Good morning. Welcome to the Long Live Third Parties podcast. Free Press Media Press, Inc., a third party's books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Stewart v. Taylor, 104 F3D 965, Court of Appeals, 7th Circuit, 1997. Friends, today we're going to talk about two things we've talked about before: the Libertarian Party and fusion voting. So these two interesting topics are combined into one. So let's go. This case involves fusion voting. That's something we've talked about before. I've mentioned how fusion voting isn't something I'd first consider. I wouldn't advocate it myself, but some third parties value it. So therefore, we are concerned with it. And we want to ponder it and reflect upon it. We want to think if it's a good strategy. We want to think about the legality of it. In this case, it involves the Libertarian Party and fusion voting. In other cases, it involved parties like the Working Families Party and the New Party. The Libertarians, from what I've seen, are not always advocating fusion voting. So this is a good thing to consider. Let's read from the record what happened. It says, quote, in early 1996, Robin Stewart declared as a Republican candidate for a seat on the Center Township Board in Marion County, Indiana. On May 7th, Stewart won the Republican primary. At its party convention held on May 1st, the Libertarian Party also nominated him for the same seat. Stewart accepted both nominations. In what is termed an anti-fusion law, Indiana requires a candidate nominated by more than one party for one office to elect which of the nominations he accepts. If the candidate refuses to choose, and it is an election for an office within a county, another statute directs the circuit court clerk of that county to make the selection for the candidate with preference given to the nomination made by convention. When Stewart refused to choose between the Republican and Libertarian nominations, the circuit court clerk of Marion County, following the Indiana statute, removed his name as a Republican candidate. Stewart appeared on the ballot as the Libertarian. Stewart sued the circuit court clerk and members of the Marion County Elections Board, asserting that they infringed his First and 14th Amendment rights of free speech, political association, and equal protection when they removed his name from the Republican slate on the ballot. End quote. It also states, quote, the relevant facts in this case are undisputed. In February of 1996, Robert Stewart filed his declaration of candidacy for a seat on the Center Township Board as a Republican. On May 7, 1996, Stewart won the Republican primary. 1 week earlier at the Libertarian Party convention, however, Stewart also received the party's nomination for the same office, which he accepted. Stewart had not informed or sought the blessing of the Marion County Republican Party to seek or accept the nomination of the Libertarian Party. At the time of the primary, neither the voters nor the officers of the Republican Party knew that Stewart had already accepted the Libertarian Party's nomination. Upon learning that he refused to choose the Republican Party's nomination, the Marion County Republican Party chairman withdrew the party's support of Stewart's candidacy, as it no longer believes that Mr. Robert Stewart represents the party's ideologies and preferences. Because Stewart failed to elect between his nominations before August 1st at noon, the Marion County clerk made the election for him to be a Libertarian candidate. IC 38722 provides that a nomination by convention is preferred to one by primary. The Libertarians nominated Stewart at convention while the Republicans nominated him by primary. As a result of Stewart's failure to decide and the clerk's election for Stewart, the Marion County Republican Party was left without a candidate for the Center Township Board because the time for filling such a vacancy has elapsed. End quote. Friends, I read a lot to you right there. I did it all for a good reason, because the first part of it and the second part of it both contain valuable things for us to consider. I'd like to point out what happened in that last line there. It makes me want to chuckle, because the Republican Party was left without a candidate. Way to go. The Libertarian Party and other third parties are all the time talking about how the system is disadvantaging them, trying to get them off the ballot. So the Republican Party gets a taste of that medicine here. That's awesome. They had experienced that. I also like to see, although the outcome is not what our candidate wanted here, they gave preference to the Libertarian Party because the Libertarian Party had a convention rather than a primary. So this law is favoring the Libertarian Party in a sense. The law is, for some reason, viewing a convention as better than a primary. So that helped the Libertarian Party get in the ballot at the exclusion of the Republican Party. It says here that the Republican Party disavowed this candidate because, quote, it no longer believes that Mr. Robin Stewart represents the party's ideologies and preferences, end quote. Was it only because he ran as a Libertarian Party candidate? I don't know any other circumstances about this from besides what's in this case. So I don't think he said, I support more taxes. I'm against individual liberty. I am pro-choice. Or any other issues that the Republicans are known for supporting. There's no evidence in this case that he did that. So it sounds like this is sour grapes by the Republican Party for disavowing him just because he got the Libertarian Party candidate. It sounds like the Republican Party is not really concerned about ideology, but about their own hide. If they were concerned about ideology first and foremost, they would see that this candidate, even though he's running under a Libertarian Party ticket, they would support him, would they not? I like to think so. So friends, consider this. Would you ever run under two parties, like the Libertarian Party and the Republican Party? Do you like the fusion laws like this? I personally would not run under the two parties. Now, of course, they talk about in this case, as well as one of the other cases we read, where parties can nominate somebody without their express consent. So let's say I was running for an office and the Democratic Party would want to nominate me. I tend to be more left than right. In fact, I'm very left. I do have a handful of conservative views. So it's more likely the Democrats would want to nominate me than the Republicans. I don't see the Democrats ever wanting to nominate me for anything. But maybe your circumstance is different. Maybe they would want to nominate you for something. Maybe you have even more leftist views than I have. So if they nominate me without my consent, then there's really nothing I can do about it. I could sue in court like they did in the other case, but I wouldn't like it. I wouldn't want to associate with the Democratic Party. I don't support them. It may be a moot point because I don't foresee it happening, but it is something to consider. It may happen to other people who are different in orientation than I am. So maybe it's something you can think about. Our friend here, Stewart, also invokes the First and 14th Amendment. I'm sure you're sick of it by now, but I'm mentioning it again and again. These trials are involving our candidates invoking the First and 14th Amendment. Again and again. The vast majority of this. So that's a good cue we can take when we have ballot access cases to invoke those amendments. It may help to invoke other things, but we can fall back on those. There's good precedents of third parties deeming these arguments important, so we can follow suit. So friends, what do you think about this Indiana law? Do you like it? Do you want to change it? What do you think? Again, although this tended to hurt the Republican Party more, we might want to say fusion voting laws are okay. We might want to support them. Like I said earlier in this podcast, some third parties do value fusion voting. So therefore, it's a concern we can have. We want to support what our third-party friends support. Therefore, it can be an issue for our concern. So what did the court decide here? They said as follows, quote, the district court correctly followed Swamp, brackets, another case that we discussed actually on this podcast, brackets, and properly applied the preliminary injunction analysis to deny Stewart's motion for an injunction. We affirm the district court's decision and remand this case for further proceedings, including considerations of Stewart's second claim. Affirmed and remanded. End quote. So friends, let's think about this. Let us ponder this. Let us reflect on this so that we may advance third parties in the optimal way. Long live third parties. Goodbye.